morning, everyone. Please be seated. Please be seated so that we can start the program. In the fabric of justice in our communities, rooted in the fundamental principles of accountability and deterrence, it serves as a deterrent against actions that threaten the well-being of individuals and society at large. The essence of criminal law lies in its dual purpose to punish the wrongdoing and to protect the innocent. It embodies the collective conscience, reflecting the values and norms that bind our communities. In this intricate dance between individual rights and societal harmony, criminal law emerges as a dynamic force, shaping and responding to the ever-intellectual pursuit we gather here today in Nyaya Sanhitha 2023. Allow me to extend a gracious welcome to the legal luminaries gracing this august gathering who occupy the dais and Ms. K. Ramchandrika, advocate. Invite on introduction, but has been a law and has woven and the ethic work through pivotal decision, casting a discerning light on the transformative canvas of the Bharatiya Nyaya Samhita 2023. I very respectfully invite you. I request of the day with a bouquet. Now, may I additional practice in Maguna. Now, I request Ms. Hamsa and also an advocate from Telangana to occupy the dais. He also serves as Telangana representative member in his family and the General Secretary for Andivar Bouquet and Felicitations.
Sri Ramchander Garu, Professor Kalraj Chauhan, Vice Chancellors of 3 national law schools, were an eminent criminal law jurist, distinguished invitees, friends. We are delighted to organize the first discussion in this state about the new Indian Penal Code, Bharatiya Nyaya Samhita. We are all aware from 1st July 2024 it will come into force, and there's a lot of understanding, rethinking, and also how to implement is necessary in this context. I'm glad that India Foundation, Nalsala University has initiated this discussion. We are also working with the National Police Academy, Hyderabad, training all police officers in India in all the 3 new criminal laws and also Telangana State Police. This is the first such interaction with lawyers, judges, legal academics, and all of them, those who are interested in understanding the newer nuances in the 3 new criminal laws, but today particularly Bharatiya Nyaya Samhita. And primarily we are discussing about BNS 2023, which marks a significant shift from the colonial era legislation aligning India's criminal laws with modern societal needs. Thomas Babington Macaulay, we know, the youngest, the first British Indian Law Commission, at the youngest age, he came to India and drafted Indian Penal Code, and 1860 onwards we have seen. And the time has changed, over 170 years. There's a lot of contemporary development. Many things have developed. Women's movement has raised feminism, patriarchal notions. Imperialist concerns were the major concern when 1860 the Indian Penal Code was drafted. So in the contemporary time, there's a need to understand and also see how we have to interpret in the coming years the Indian Penal Code. I'll not take much time. Briefly, I'll just say a few words, and then we will look forward to Ramchander garu and Narasimhamurthy garu, and then we will request Honorable Justice Lalit to deliver the keynote address. So the repealing of the Indian Penal Code and the introduction of Bharatiya Nyaya Sanhitha aims to streamline provisions, make certain offences gender neutral, enhance punishments, to streamline provisions to make certain offences gender neutral, and in fact in the law, language plays a very important role. In fact, the English and the jurists, they started what is called as a plain English movement. How do we move from the archaic words and simple English? How do we use the simple English? Plain English movement in UK and all over the world is trying to look at simplifying the law, demystifying the law. I think some effort has been made in this new Bharatiya Nyaya Sanhitha. The overarching goal is to create a citizen-centric legal structure that ensures ease of living and provides speedy justice to the common man. And I'll stop here, and then I'll request Sri Ramchander garu say a few words, and then we will have other panelists will be speaking on this. Thank you, and we look forward to your interactions and this in this one-day session. Thank you.
Thank you, sir. Honorable Justice Sri Inaugural, former Chief Justice of India, Sri Narasimha garu, Additional Solicitor General, Sri Krishna garu, Vice Chancellor, Nalsar University, Hyderabad, retired judges, sitting judges, and members of the bar, students, academicians, and others who are present in this seminar today. Very good morning to you all today. This seminar was thought of by the India Foundation and the Nalsar University together to discuss on the newly enacted and replaced laws from the earlier colonial laws which we are having. The three laws which the criminal major acts which we call, namely the Indian Penal Code, the Evidence Act, and the Criminal Procedure Code. These are the three major acts which any criminal advocate or any criminal justice system would generally contribute or rather follow. And these laws were formed and were in force since before independence. And there was a need because of the changing society, because some sections and provisions are outdated. The need of the hour in the present society are different. Now, after 75 years of Indian independence, in the Amrit Kaal, this process of decolonization has to be begun. And therefore, the Honorable Prime Minister has taken a step. And this step is nothing but, firstly, decolonization of the criminal justice system. And in this regard, three major laws were introduced in the Parliament. And that is Bharatiya Nyaya Sanhitha, and then Bharatiya Nagarik Suraksha Sanhitha, and Bharatiya Sakshya Adhyayam. And these three laws, which will replace Indian Penal Code, Criminal Procedure Code, and Indian Evidence Act. Friends, we all know that the modus operandi of the criminals are the victims crying for the justice, the demand for justice. All these things have been discussed from various commissions, before many before us. Malimat Commission was there. They recommended certain things. From time to time, Law Commission has also suggested certain changes in the laws. So therefore, in the last 75 years, it was thought that a comprehensive decolonized criminal justice system has to be introduced in the country. Because in many courts, including Supreme Court, on many occasions, especially on the question of sedition, they have been suggesting the government, because these are all colonial and these laws were made when the British was ruling us. So therefore, there is a change of laws in our country. And keeping all this in view, the government of India has taken a decision to change the entire criminal. Basically, the new provisions are added, and those which are relevant, they have been kept, and those which are outdated and which are not relevant have been removed. So new provisions have been added. So that's what is a reform. Basically, it is a sort of reform. And definitely, this new laws has to be educated to people. And those who are the stakeholders, mainly the police, the judges, the advocates, they have to be, in fact, educated first on this. And I think this is the first of its kind, first seminar organized by India Foundation, Nalsar University. First in the state, I don't know what about in other places in the country, but in the first conference, first seminar in the state we have started here. And I thank the organizers, especially the Nalsar University and India Foundation, for taking the pains of conducting this particular seminar here in Hyderabad. And I also thank the participants here over here, because we have two different sessions. That is, one is a session on the offences relating to body and women. Secondly, offences against the state, that is sedition and other related aspects. So these are the two areas where we'll have discussions, and we'll have two, and panelists are also here. They are experts in their own field, and they will be chairing that, and they'll be conducting that sessions soon after this inaugural session is over. And one more thing is that the earlier laws, we thought that it would deliver justice, but more than delivering justice, people thought they were oppressive. So therefore, this is also one of the reasons that a need for the change had come. After all, change is law of life and change is law of nature. And we have been facing several difficulties. We have challenges in implementation of several laws and acts in this huge country. So I think we have to welcome the step of the government of India for having taken this initiative to replace the old criminal measure acts with the new criminal measure acts. With these few words, I think this seminar will definitely be a fruitful seminar, because students of Nalsar and other colleges are participating. We have limited the participation in this seminar because this is basically an academic-oriented seminar. And those who are practicing mainly on the criminal side, we have invited those advocates who are leading in the criminal courts here. Those judges who have been dealing with the criminal cases, we have invited them. And I thank every one of them for having attended this morning session. Thank you. Thank you very much.
Thank you, Ramchander Garu, for laying down the discussion and the foundation for the next speakers. Indian Penal Code so far roughly has been amended 60 to 70 times. Major we could see from 1984 onwards, 2013, 2018. But unlike a comprehensive reforms in the Indian Penal Code like UK, US, Australia, Canada have not been undertaken, is what the criminal law jury says a piecemeal approach when it comes to the criminal law reform. Or if there is an incident happens and suddenly we look for amendment to that. Not a comprehensive method of approach, but piecemeal method of approach which is being, we could see over the years. And thank you for highlighting some of these. Now I would request Sri Narasimha Sharma Garu, Additional Solicitor General of High Court, Telangana. Please briefly share your thoughts.
Namaskar to all. We had a great privilege to have the first seminar in Bharatiya, Hyderabad on the new legislation by the Parliament, that is Bharatiya Nyaya Sanhitha. None other than the most illustrious jurist on the globe and the great Chief Justice of our Supreme Court of India and a leading lawyer on the criminal jurisprudence. So, not staying in between before hearing His Lordship's Justice Lalit, I only said 2 words. If we see the silent pages of this Bharatiya Nyaya Sanhitha, it has introduced, particularly for this offences against the state are concerned. Earlier we were dealing with the Unlawful Activities Act, investigating agencies like Nyaya. We have the special provisions under the other stringent laws like Narcotic Drugs Act, or even the Money Laundering Act, insofar as those offences are concerned, which have the threat to the national integrity and the other complications at national level. I feel that insofar as those offences are concerned, a salutary initiative has been taken now, because the definition of terrorist act we find only in UAPA. Unlawful activities are also, it has its own parameters. And when we come to other offences which are has a tremendous impact on the national economy, it has been developed based on those special statutes, and we know that again the jurisdiction of these special statutes are only again with the special courts, and it has its own procedure. To initiate a case before the NIA Special Court, we require a notification for the offence at so and so place to the Ministry of Home Affairs. Investigation at the state level, then followed by notifications there. And similarly under the Delhi Police Act also, even to go for the CBI and other cases where such a serious impact to the national, that is against the state, are involved, such a cumbersome procedure we were facing here. In that scenario, an attempt to have this definition of terrorist under the Bharatiya Nyaya Sanhitha, and also very alarming increase of offences against the women, children, and these things require a more stringent indication to the society to prevent the commission of the offences. So that initiative also has been made in the Bharatiya Nyaya Sanhitha, and most important is some of the offences which doesn't have such a serious impact, the punishment is made in a way to introduce the social reformity while convicting the accused persons. So these are the things, as if we follow the debate in the Parliament while passing this statute, various suggestions have come. We are at the stage of implementation of this new law. It requires periodical, that is supervision, and recommendatory provisions by way of amendments has to be brought. A great initiative by the Union government is keeping for last 2 centuries. This law requires to go on par with the changing trends in the society, particularly involve the technology in the process of criminal jurisprudence. And these are the most welcome initiatives in the Bharatiya Nyaya Sanhitha now. And I compliment the organizers, India Foundation and the prestigious Narsar University for organizing this seminar for the first time in Hyderabad. In fact, I came to be amongst all of you in the audience. Suddenly I received a spot request, my friends, to be on the dais. I feel blessed to be amongst you all today. We all look forward to great illustrious jurist of this country, U.G. Lalit. I had one special mention. I had the great privilege of going to senior Lalit, and many times I had interaction with him. When he came to here, I went to receive your Lalit, such a great personality, not only as a judge, retired judge of Nagpur High Court. If we spend 10 to 15 minutes with the senior Laliji, you will be blessed for the life on the basic principles how to behave and his decency and affection to even a small man who comes and meets to him, and totally informal personality. Really, sir, we are blessed, sir, for your presence today. I again apologize for saying few more words here, but I take you, we are all looking forward, we'll have the guidance, we are all blessed, sir, for your guidance today. Thank you very much for the organizers.
Thank you, Narasimha Sharma garu. Before inviting Justice Sanhitha, I wanted to share two points. One is, some of you may be aware, the rethinking on rarest of the rare case jurisprudence was inaugurated and a new jurisprudence is created by Justice Uday Lalita. So I wanted to inform all of you, we know that rarest of the rare case, Bachchan Singh is the only one. But when Justice Lalita and Justice Ravindra Bhatt, Justice P.S. Narasimha and other benches also, first time has created a new jurisprudence called as a mitigation specialist is required. And you could see several of these judgments. I think that's one you could see even in the new Bharatiya Nyaya Sanhitha, Criminal Procedure Code. Sentencing justice, sentencing policy is taken very seriously. And that's the reason community sentence is also suggested. That's the one. And second, the criminal law reform, particularly the criminal law CLRC, Criminal Law Reforms Committee, was appointed by the Ministry of Home Affairs in May 2020. Professor Barraj Chauhan sir is the senior most and contributed many things in that. We are also part of this committee with 5 members, May 2020 to till 2023. And then later on also several discussions happened, and now we see this Bharatiya Nyaya Sanhitha. Several discussions happened all over India. The law schools have participated, judicial academies have participated, lawyers, police officers, all associations, threadbare discussions happened over the 3 years. And over to Justice Lalita, we look forward to hear you, sir. Thank you, sir.
Dr. Krishna Deva Rao, Learned Vice Chancellor of Nalsara University, Shri P. Narasimha Sharma, Learned Additional Solicitor General of India, Shri Ramchander Rao, Senior Advocate and associated with the Bar Association here, some of the retired judges, some of the present judges who are present today, all the distinguished members who are present in the gathering, senior advocates, students, persons coming from the faculty, ladies and gentlemen. The topic for discussion today and in these 2 segments pertains to new codes, which are the procedure as well as substantive law codes, which are going to come into existence from maybe just about a few months away. Last year saw some of the greatest churning of ideas. So the first bill was tabled. There was some opposition in the House. So it was withdrawn, came with further amendments. again matter of discussion, and finally what we have before us is what is called Bharatiya Nyaya Sanhitha. We all know that it was the imperial power which gave us this Indian Penal Code. Indian Penal Code was one of the instruments which was employed, which was utilized and used by the imperial power to rule over we the Indians. But substantively, the provisions of the law had stood the test of time. And we haven't found many areas for grievance to say that perhaps I think the law needs amendment or law needs complete modification, except for some of the sections or some of the provisions like sedition, which was essentially to protect the interest of the imperial power that the particular offense was put on the statute book. We all remember the case of Bal Gangadhar Tilak versus the emperor and the defense statement of Bal Gangadhar Tilak. What he advocated, a government by law established doesn't mean opposition to any person or any authority in government. It means with an idea to completely overthrow that government if there are any statements, words or spoken or otherwise. Then perhaps I think the matter may come within the sphere of sedition. That's exactly what the Constitution bench stated in Kedarnath Singh, and that had stood the test of time. But we have now, of course, the time was right. A stage was set for rethinking in the matter and perhaps to have completely revitalized the idea in the form of new code, which we have now before us and which will be part of our life in few months' time. Now, therefore, seminars such as this, which will bring people together, stakeholders together, so that there is good amount of discussion on the point. There are exchange of ideas, and what gets churned out of the process is something which will be good for the society, good for the lawmakers, good for the administration of justice. But I have some of the points, and on some issues I think this Bharatiya Nyaya Sanhitha has done an exceedingly good work. Good thought process is getting translated into the enactment of relevant provisions. But at the same time, perhaps there are certain provisions which are not so clear and which may give rise to elements of doubt. Doubt in the sense, what does the legislature exactly mean by that? Now take for instance, we have principles of vicarious liability, and since we have been taught, we have learnt our law under the umbrella of Indian Penal Code. If I may give just the instances of vicarious liability, principally under say 34, that is to say where participation is the key to the entire process, common intention. Then the second would of course be abetment, where you simply abet commission of an offence, though the committer, the person who commits the offence, may be somebody else, and therefore you are also vicariously liable. Third, conspiracy, where perhaps I think you instigate a man to pull a trigger. The man sitting in his office may not even be present at the scene of occurrence, and yet somebody loses his life, and the person concerned could still be liable. So that's the element of conspiracy. Then perhaps what you have is unlawful assembly. If 5 persons storm into a house where a common intent is supposed to commit an offence, and even if only one out of them commits the offence, the other 4 are also equally liable. So that's the element of vicarious liability with which we fasten the liability on their shoulders. Then of course dacoity, etc., these are all principles, modified forms of that. Now it is with this interest that if you look at these provisions in the new Bharatiya Nyaya Sanhitha, perhaps I think there is an element which will leave you with a sense of doubt that what does the legislature exactly mean by that. Now take for instance conspiracy. It's the classic idea of a conspiracy theory is there are certain decisions where it has been stated that conspiracy is like a running train. You may board the train at any station after it has left. You may deboard at any station before its destination. Yet you are liable for everything. So supposing if the train is going from A to B and you board after A and deboard before B, even then you are liable. Why? You may not even know what is the ultimate object. That is precisely why cases like, say, what happened in Bombay on 26/11, where the material had come, or what happened in Bombay when the blasts took place in Bombay. The contraband material had come at a place. It was transported from A to Mumbai by some set of accused, finally utilized by another set of accused to cause the explosions at various places in Bombay. Now the first set of accused may not even be aware as to what is the nature of the contraband, what is the volume, what is the intensity of that contraband material, the explosive substance. Yet they would be part of the conspiracy. On this theory that you may join the train at any juncture, you may deboard the train at any juncture. So there is nothing such as quote-unquote common object which drives them. If you go by that classic theory. But now today in the definition of criminal conspiracy, there is an expression which finds its presence, and that expression is common object. Now if you borrow the ideas of common object which are otherwise present in old section 149, then it would mean that the presence of the man is necessary, though he may not have done any overt act. But the presence at the site, at the scene of occurrence, if you go by the classic notions of law which has developed under Indian Penal Code, then perhaps his presence may be necessary. Then you are completely turning upside down the entire theory of criminal conspiracy. Conspiracy is what? Supposing if you are hiring a hireling to commit an offense, pull a trigger against somebody, you may not be present at the scene. But even if that man pulls the trigger and somebody loses life, you are still liable. You will be hundreds of kilometers away from the scene of occurrence. That is precisely why the old definition of criminal conspiracy never used the expression common object. In fact, that was amplified by one of these subsections to say that you may not have the intent to commit the ultimate object, to go by the ultimate object. Now, the text of the old 120B and 120A get bodily lifted in the present provisions with the addition of expression common object, and now you have, to my mind as a student of law, perhaps a situation of dichotomy. Now, I'll read those provisions slowly for the consumption of everyone. And this is where perhaps I think I'll be able to just impress upon the entire gathering what I have in mind and what is bothering me. If you just turn to the definition under section 61 of the criminal conspiracy under Bharatiya Nyaya Sanhitha, what does it say? It says, when two or more persons agree with the common object to do or cause to be done, an illegal act, etc., etc. The earlier definition was when two or more persons agree to do or cause to be done, so on and so on. The complete absence of what is called common object. And there is one subsection which also says, or the explanation to the section, which says, it is immaterial whether the illegal act is the ultimate object of such agreement or is merely incidental to that object. So therefore, by definition, by logic, we had accepted the notion that the first set of accused who just got the contraband from a launch and took it to the shore may not be aware of the ultimate object. It is immaterial what is your ultimate object. You are still liable. Now the moment you say it is immaterial what is your ultimate object, where is the idea of common object and seeking in? That is why, as a student of law, perhaps according to me, these are inconsistent ideas. And this is going to lead to a tremendous amount of debate, discussion at the bar. And this will lead to elements of uncertainty and a principal provision with which we can fasten the liability on conspirators will get diluted. So the rigor or the severity of this punishment, of the provision of conspiracy, we may find coming under a question mark. And that's only with this introduction of common object. If your idea is to have the very same logic of common object under unlawful assembly, that is to say, presence at every juncture, then sorry. Then this provision is not going to serve the purpose. So this is why, on certain scores, as my previous speakers were at pains to say, that perhaps the time was right to have a rethinking in the matter. Yes, we have done that. But at the same time, I don't know whether it is the error committed by the draftsman or is it something which is with clear design. The earlier 120B never had this element of what is called common object. And therefore you are now creating a hybrid idea in the theory or genus of conspiracy. So therefore perhaps I think, we as persons who will be definitely concerned with the administration of justice, those who are in the executive police department, those who are prosecutors, those who are judges, need to now concentrate more on provisions such as this. Very well, this was one. Now, there are certain provisions where perhaps I think the punishment has been enhanced. With the passage of time, we have learned from our experiences. Now, take for instance, culpable homicide not amounting to murder as a result of rash and negligent act. That rash and negligent act may be because of your reckless driving, maybe because of negligence on part of medical professional, maybe because of negligence on part of somebody who is supposed to be a caregiver. Under the old 304 Part A or 304 capital A, the maximum sentence used to be for 2 years. And therefore we had so many such cases where the vehicles have run over the people, where the vehicles have rammed into some of the jhuggi-jhoppadis, so therefore killing people, and yet, what is the ultimate sentence? 2 years. The travesty of justice was that even in Bhopal gas leak disaster case, the sentence which was given was 2 years. Why? Because the finding was rendered it was a negligent act. And that's where what perhaps I think rethinking was definitely required, definitely necessary. And today the provision, which is the parallel provision to that, which is perhaps section 57 of Bharatiya Nyaya Sanhitha, now speaks in 3 different tones. Number 1, if as a result of any rash and negligent act, a death occurs, then it would be 5 years, not 2. So it may extend to 5 years. Secondly, as a subset of that, if the vehicle as a result of which the death is caused, or the person who is responsible for causing the death by a rash and negligent act vanishes from the scene. There have been hit and run cases that we see so many times. People after the accident don't even wait for that, don't even try to give first aid or some sense of comfort to the person who has been the victim of that. Then if such conduct is exhibited by the person who is guilty of the offense, then the sentence can be 10 years. So therefore now 2 years at an advanced level of 5 years, and if there be such illustrious conduct, then 10 years. But at the same time, the legislature is careful to say that if as a result of some medical negligence, something happens and the life is lost, it will still be only 2 years. So what was originally 304A, which carried sentence of 2 years, now you have 3 levels of different ideas which are emerging from the parallel provision. So 5 years, aggravated for 10 years, and for medical professionals, again only 2 years. Which is such a welcome provision, Because then you were bundling everybody in one single basket, that is rash and negligent act. What kind of act? Rash and negligent act. What kind of, under what circumstances? If suppose somebody is actually under the influence of alcohol. That is precisely why some of the High Court decisions went to the extent of saying that if you are under the influence of alcohol, then not under 304A but 304 Part 2. God knows, yes, that's why, because as a judge perhaps I think you feel compelled that your sense of justice doesn't sort of get satisfied that for the loss of life, where that case which was Alistair Pereira, 7 persons of a family lost their lives. Why? A car will run over them. So therefore your sense of justice doesn't accept that, and therefore you try to put it under some different slot. Not necessary anymore. You still have something which is an adequate punishment provision which is guaranteed. So therefore that's number 2. I have such 6 or 7 instances. This is only to sort of brush up our ideas. Then the third one, there is a particular section. Sorry, that section was not 57, it is 106 in the present code. Section 57 is abetment by public or more than 10 persons. It's a very specialized provision where, supposing if abetment is done by 10 or more persons or by public, the wrath of public, the anger of public, and public is actually responsible. So under the old law, it used to be only 3 years. Today you have extended it to 7 years, made more comprehensive, more sort of, worthy of some kind of substantive idea. So therefore that was the third provision which I wanted to place it for the consideration of this August gathering. So therefore 3 ideas which emerge out of that. Now the fourth one, and that is to say, when it comes to rape on a minor girl, the present code has made distinctions at 2 places. If the girl happens to be less than 16 years, then the punishment can be aggravated punishment. If the girl happens to be less than 12 years, again an aggravated form of punishment. But unfortunately, the quantum of punishment in both cases is identical. So then, what is the distinction then? You could simply have said girls under 16 and everything would be covered. You don't have to make a further distinction, girls under 12. Either if there is supposed to be a different idea or a filter to be adopted, there is no such filter which is indicated in the statutory provision. So therefore, again, I don't see any reason why there could be internal distinction of a category or a cadre such as this, below 12, below 16. If you happen to be giving the same punishment, which is to say 20 years in both cases, it hardly makes any difference. Unless you were to say that very well the norms of punishment will be slightly stricter or harsher or harder. Then one more criticism which is some of the social thinkers and legal scholars. At one stage, if you recollect, after this Nirbhaya case in Delhi, there was a committee which was headed by Justice J.S. Verma, of which Justice Gopal Subramanian was also a member. That committee went into certain issues and suggested some of the modifications to the Indian Penal Code. And one of their suggestions was that make rape an offense which is gender neutral. So not necessarily minor girls, even minor boys can also be subjected to a very, very very dark kind of offense, which may leave a great imprint on their persona and which will damage their entire personality all through the life. And so therefore, let the rape as an offense be gender neutral. But unfortunately, that was not accepted as in the Indian Penal Code stood before this Nyaya Sanhitha came in. And again, the same definition has been borrowed here. So therefore, the rape has to be only upon a female child or a female or a lady or a woman. So the gender neutrality principle perhaps has not been accepted by the legislature when it comes to offense of rape. Now imagine you have expanded the scope of definition to say insertion of any kind. Why doesn't it apply to minor boys? It can also have a disastrous effect on them. So therefore, that's one area perhaps I think the legislature should have given a good thought, or at least made a comparable or parallel provision where perhaps with lesser, stricter ideas, you could still have made contingencies or situations such as that. So that's my third idea which I am presenting before you. Now section 152, I gave in the opening remarks the case of Bal Gangadhar Tilak versus Emperor. Now he was convicted of sedition, sentenced for 6 years. For what? All that he published in his newspaper, Kesari, was criticizing the action on part of some of the officials of the government. Whether that would come within the definition as to say whoever challenges the authority of the government established by law. This is what his address was, that he said that as a citizen I have every right to say, criticize the actions of the government or the authorities or the officials who comprise of the government, and that will never amount to sedition. Of course, he lost the case. The very same idea gets translated in Kedarnath Singh. And today we have completely amended the definition. Of course, the idea being that perhaps the legislators thought, the parliament thought, that sedition as a law was essentially by the imperial power to keep under control the natives or the original inhabitants of this land. We don't require that kind of stricter idea. So therefore we have now a completely different definition which is on the statute book now, and that definition now says act endangering sovereignty, integrity or unity of the country. And that to my mind is a great service which has been done by the parliament to the citizens of this country. Because the moment you say that any act which is endangering sovereignty, unity and integrity of India, the act would be at the highest level of the pedestal. Mere criticism of an official of the government could never come up to that level. So therefore, there has been a clamor, there has been a demand that Kedarnath Singh requires reconsideration. And some of the cases are still pending in Supreme Court. With this definition, perhaps I think that coast now gets completely buried. So therefore, that's also a good idea. Then comes the next level, which is, as the learned Vice Chancellor said, that some of the ideas like organized crime, some of the ideas like terrorist act, now for the first time find a mention in a union law. You know, some of these organized crime legislations are state enacted legislations. Maharashtra Organized Crimes, so and so Act, Control of Organized Crimes. On Maharashtra has been modeled Gujarat, on Maharashtra has been modeled Karnataka, so on and so forth. So the path-breaking idea came from Maharashtra. The validity of that act was under challenge in Supreme Court. It's a judgment by Justice Mukundakam Sharma along with Justice Ravindran. And in the definition in that, what is organized crime? What is criminal activity? The state legislation said everything and also said last expression was for promoting insurgency. Now this last expression, promoting insurgency, was the subject matter of discussion and debate before the Supreme Court, because the submission was promoting insurgency or anything touching upon ideas such as insurgency would be a union subject, not a state subject. And therefore the state legislature would be incompetent to rule, incompetent to enact any legislation touching upon insurgency as an activity. So the Supreme Court went into the entirety of the matter and on principles which are normal principles of pith and substance theory. They found that the state legislation was a good legislation. Now, mind you, it was a state legislation, and they traced the power to topics under list 2. Now, today we have a union legislation, which is now for the first time putting in the statute some of the definitions such as organized crime. Of course, that will be a subject matter as and when perhaps I think somebody wishes to challenge that, whether it will still come under or within the domain of the Parliament to come out with a legislation touching upon what is called organized crime. Of course, everything depends upon the definition. The definitions are not identical. The definitions have undergone a complete change. And that is precisely why perhaps I think the Parliament needs to be congratulated to say that they are now trying to expand something. And with the passage of time, whatever we have learned from our experiences, also to categorize something as an offense and put it under the central statute. So therefore, we now have what is called organized crime syndicates. What is the idea? Who is part of that syndicate? Who is part of the group? As a member of the group, can you still be punished or not? It's an entirely new domain which has now been implanted in a parliamentary legislation. Up till now, it used to be part of state legislations. So it's now part of the parliamentary legislation. So therefore, that's very, very new idea or era which is emerging as a result of this Bharatiya Nyaya Sanhitha. There's alongside this what is called organized crime. Normally we take it that very well, something such as, say, creating blasts in a city, creating some kind of, terrorist activity, or the matters which are of that dimension are what is called organized crime. But there could be organized crime which may even be selling black market tickets at the theatre, which may be an organized activity. Even such petty organized crimes are also part of now what is called the dragnet of offences under this particular Bharatiya Nyaya Sanhitha. So therefore, there are two areas in which the Parliament has now embarked upon and has given us new dimensions to what the social thinking on the point is, that perhaps these activities, chain snatching gangs, the gangs which try to sort of, take away the vehicles, there can be various activities. So therefore, this is something which is also being brought within the net of what is called the culpable activities. Then comes what is called terrorist act. Of course, up till now, terrorist acts, say whether TADA, whether any other act, It always was a parliamentary legislation. So therefore, there shouldn't be any problem when it comes to legislative competence to deal with an issue like that. But instead of putting it under a separate legislation, which was Terrorist Anti-Disruptive Activities Act, now we have put it in the same basket, which is under the Bharatiya Nyaya Sanhitha. So therefore, it becomes a more comprehensive legislation, which deals with perhaps very different and at the same time diverse kind of criminal activities. And therefore, this is also a very welcome step which the Parliament has come out with. So I gave to you some 6 or 7 instances where perhaps I think the pluses and minuses which emerged out of that. I have said minuses when it comes to a common object which finds mention in conspiracy as a definition. Pluses are in some of the other provisions. So therefore, this is what some picture I have tried to portray before you, with the idea to say that this new Nyaya Sanhitha is something which will be catering to various difficulties, various inconveniences, various crimes which we regularly are confronted with. But has it taken into account everything? Now take for instance cryptocurrency. Cryptocurrency today and crypto crimes is also a reality. There is no such legislation which deals with that. We still have to rely on what is called the normal definition of extortion, normal definition of theft, normal definition of anything else, and then say that anything touching upon cryptocurrency or crypto crime would also get included there. Now with the inventions, there's a different personalities now emerging. There may be a very, very diffident person in real life, but he creates an identity in the virtual world which may be of a different nature altogether. So he has a persona in the virtual world which is completely different. So now the legal thinkers say that whether the defamation of that person, will it be an actionable wrong? Whether anything happens to that person, will it be an actionable wrong? And that's also a new dimension which is getting added, that is to say in the internet or the virtual world or the data world or the digital world. What are the significances, what are the ideas which emerge out of that? And that is where one such subset of that is actually your crypto crimes. But that's an area which up till now, perhaps I think the Parliament has chosen not to deal with that. Maybe with the passage of time, certainly it will be a situation. And that's why some of these cyber crimes, which actually have transnational kind of effects. So therefore, that's again an area where perhaps I think element of certainty would be a demand of the time. And maybe in coming years, perhaps I think the Parliament may choose to intervene in the process. So all in all, what emerges is, if you take the sum total, a brilliant exercise, a commendable effort, which is to give us our own Nyaya Sanhitha, or a code for us, which is devised by us, which is enacted by us, which is given to us by our own people, rather than being thrust upon us by the imperial power. So therefore, greatest advantage on that count. But there are certain provisions which perhaps, I don't know, as a student of law, I say that I may concede that perhaps they may have a different viewpoint, but that is not getting cleared as of now. So therefore, to sum it up, in my view, a good exercise undertaken by the Parliament. Provisions are wholesome provisions. Provisions are designed to achieve what is called greatest good. And something which I told you about this 304A, because that's the fast cars and fast vehicles and the way negligence is getting exhibited all through. Perhaps I think stricter idea was the call of the day. So therefore this is where our Parliament has chosen us to give new Nyaya Sanhitha. Let's welcome that. Thank you so much.
Present the new book, new 3 criminal major acts. Yes. Thank you, sir. Wonderfully highlighting some of the inconsistencies and also the advantages of the BNS over the earlier Indian Penal Code. Now we will break for tea and we will reassemble in 10 minutes for the next session. Thank you.
అల్ల పెట్టవకన్నా లోడ్ ఎక్కువైంది
Momento, please wait for.
సరిపోతుంది అన్న లైటింగ్ సరిపోతుంది ఉన్నది పోయింది మళ్ళీ ఒక్క నిమిషం బ్రో
Break for tea.
సర్టిఫై చేసుకున్నాం ఇప్పుడు అవసరం స్టార్ట్ అయ్యేటప్పుడు చేద్దాం అది లోడ్ ఎక్కువైందన్న, ఎందుకు అది సరిపోద్ది కదా, 3 లైట్లు ఉన్నాయి. చూడు బల్బు పోయిందా? చెప్పండి ఏం కావాలి? ఒకసారి
9 rupees. 9 rupees cannot even buy you this packet of biscuit. But what if I tell you that 9 rupees can help you save your job? What if I tell you that 9 rupees can 3x your salary? What if I tell you that 9 rupees can help you stay relevant at your job forever and make you irreplaceable in the job market? Yes, this is possible because I am going to conduct a workshop at just rupees 9 on ChatGPT and
serving as an assault commander with the Greyhounds, she spearheaded successful operations against left-wing extremists and combating women and child trafficking. Heralded as the first female IPS officer from Munnar, Kerala, and the top graduate of the IPS class of 2009, she has pioneered the community outreach program addressing societal issues like child labor, child marriages, and women empowerment. Her collaborative policy approach breaks gender stereotypes, fostering leadership among women. Ms. Rema often writes and speaks on women issues and crimes. A very warm welcome to all the three speakers. Over to our chair to conduct the proceedings.
Sri Krishna Devaragaru, Vice Chancellor, Sir, and Madam Rajeshwari Garu, present and former judges, and the senior advocates, professors, intellectuals, and my dear young advocates friends. Today, in this session, we are dealing with the offences against the human body. I am truly honored to stand before you today as a chairperson of this esteemed seminar on Bharatiya and Nyaya Sanhitha 2023. Today's seminar holds significant value as it brings together a diverse array of legal minds, practitioners, scholars, and intellectuals to dwell into the intricacies of the new law, that is Bharatiya and Nyaya Sanhitha 2023. It is an opportunity for us to engage in robust discussion, exchange insights, and explore innovative perspectives that can shape our understanding and application of the same to the legal landscape. In India, Indian Penal Code 1860 defined numerous offences against human body. Especially the chapter 16 of IPC dealt with offences against human body from section 292 377 covering murder, dowry death, attempt to murder, causing miscarriage, hurt, wrongful restraint, wrongful confinement, criminal force, stalking, assault, kidnapping, abduction, trafficking in person, harassment, offences against children, unnatural offences, etc. The government of India, in the process of Indianization of criminal law, replaced IPC with Bharatiya Nyaya Sanhitha 2023. We can call it as a BNS. Bharatiya Nyaya Sanhitha 2023. The offences relating to the human body are divided in two chapters. One is chapter number 5 containing sections 63 to section 99. Deals with the sexual offences and other offences against women and children. Coming to the other chapter, chapter number 6 containing sections 100 to section 146 deals with offences affecting life, hurt, wrongful restraint, wrongful confinement, criminal force, assault and kidnap, etc. Bharatiya Nyaya Sanhitha is an attempt to contemporize criminal law to keep in tune with the evolving times while balancing a deterrent effect and by removing absolute archaic offences of British era. BNS has included new offences under its ambit, which include organized crime, specific offences arising out of negligence like section 106 by death by rash and negligent act, and also the medical practitioners, mob lynching, offences relating to terrorism, etc. Further, in the light of judicial pronouncements and changing times, BSN has not included certain offences like adultery, sedition, attempt to commit suicide. Removal of attempt to commit suicide as an offence is a progressive omission that used as a mental health care basis as a same is opposed to a crime. A preliminary understanding of the relevant provisions of Bharatiya Nyaya Sanhitha reveals that the offences against the women and children are taken very seriously and severe punishments are prescribed for the same, including by enhancing the periods of punishments and also the quantum of fines payable. Speaking about the punishments, an essential inclusion of the BNS is the incorporation of community service as a form of punishment. Under section 4F, it's worth noting that BNS has introduced a non-custodial and reformative form of punishment, that is community service, for petty offences, marking significant departure from the traditional punitive measures. BNS attempts to bring some positive changes in criminal law. There is an expectation that the administration of criminal justice in the country will enter into a new era. However, certain redundant provisions have been still retained and a complete overhauling has not been done according to me, but let us hope future amendments to them. And what I personally feel that while undergoing this certain special the proposed amendments and provisions comparatively the earlier law and now is a positive and which really, as just now said by Honorable Justice Garu, is need of the hour and suitably for the present times. The central government has undertaken the amendments to the IPC, that is the Bharatiya, Nyaya, Sanhitha and other acts. And according to me, is welcoming amendments. Little bit, one or more, while exchanging our views and all intellectuals, they can suggest something so that we can have future amendments to that effect, which really suits to the present scenario. With this brief insight, I would like to invite our speakers who are esteemed authorities in their respective fields. Now I request Sri Krishna Devara to comment.
Friends, I take 15 to 20 minutes briefly to highlight what are the interesting new features which were introduced in the Bharatiya Nyaya Samhita. Now we have to familiarize and by heart some of these Indian idioms. I was just looking at, that's one way of moving towards Indianization. And code is now Samhita and Bharatiya Nyaya Samhita. I think that's a good way of new phraseology we need to accustom and understand. Let me look at briefly, firstly, gender neutrality. I also said in the first inaugural session, I think that was taken much more seriously. That was the major, one of the criticism against the Indian Penal Code. So in the light of these reforms, the Bharatiya Nyaya Samhita attempted to promote gender neutrality in the nation's criminal laws. Primarily expanded the term gender, and the first time it includes male, female and transgender. Of course, just as Lalit said about not inclusion, non-inclusion of in the rape, even the male and 12 and other years, but that we will take into consideration. But the first time you could see this gender was included both male, female and transgender. BNS also enlarged its scope of applicability in terms of individuals who can seek recourse as well as those who can be prosecuted. Several offences including voyeurism, assaulting of women with an intent to disrobe have been made gender neutral from the perpetrator's perspective. In fact, just as Lalit said, there was also discussion when they were drafting. They wanted to bring in the cybercrime also, not in the Information Technology Act, but to bring in that, but they could not succeed because we know cybercrime is also very important. What we have seen, it is cross-border and also has a technology implication. But this several offences, voyeurism and the assaulting of women with an intent to disrobe were made as a gender neutral. This represents an advancement in laws aimed at safeguarding women and gender-based violence within the dynamic shifts of social structures. Similarly, under sections 76 and 77 of BNS 2023, the offences of assaulting or using criminal force with intent to disrobe is already said, which is again made gender neutral. And this is primarily towards gender neutrality and ensure that the legal provisions encompass a broader range of situations, acknowledging both genders which can be affected by or involved in this crime. Second is age disparity. We could see in the response to the evolving social perspective on the age and consent, the BNS played a pivotal role in rectifying this gender-based discrepancy. The historical age disparity we know between girls and boys, stemming from the 19th century socio-political conditions, has been effectively addressed by the BNS. Previously, the age criterion for kidnapping of victims differed based on gender, reflecting an outdated mindset. The age criteria for victims of kidnapping has been standardized at 18 years regardless of their gender. This is in the light of the Supreme Court judgment in Indian Independent Thought vs. Union of India 2017. The age bar under the clause has been finally raised to 18 years in the text of law, as well as amending the exception 2 to section 63 of BNS. By eliminating the gender-based age distinction and aligning it with age of majority, the legal framework now better reflects contemporary societal values and commitment to gender equality. Third, gang rape punishment. The age-based distinction for punishment in case of gang rape of a minor girl has been eliminated. Section 70 clause 2 now mandates life imprisonment till the remainder of the offender's natural life or the death penalty for the crime of gang rape committed against a woman below the age of 18 years. This change removes any variance in punishment based on the specific age of the victim and imposes stricter penalties to ensure the severity of punishment for such heinous offences. Mob lynching. Of course, we have first time introduced mob lynching. You also have some historical significance about this. There is an honor killing and mob lynching were in discussion for last 5 to 6 years, even more. In fact, when we were deliberating in the reform of the Criminal Law Reforms Committee, Professor Bharatiya, who is here, who was there from May 2022 onwards, and we were looking at a broader definition of categorization of murder. In fact, one of the senior member, Professor B.B. Pandey, who is a guru to both of us, who is our mentor, who is an eminent criminal law teacher, who taught in Delhi University, who was involved in the drafting of the Juvenile Justice Act and several other. He was, in fact, he was the major expert consultant in the Criminal Law Reform Committee, and he worked very hard. His ideas we wanted to expand this, not just including only mob lynching, but also honor killing. We wanted to include even a custodial death. But partly, I think I'm happy that partly we have succeeded, maybe. Witch hunting also. There is a categorization of the murders. The committee worked on the draft, which also wanted to bring in dowry death. In fact, the categorization I wanted to just inform, we suggested 300A, dowry death, not 304B. We also suggested 300B, death in the name of honor. We also suggested 300C, death in the name of witch hunting. We also suggested 300A, dowry death, 300B, death in the name of honor, 300C, death in the name of witch hunting, 300D, death by lynching, 300E, custodial death. Because already we know custodial death with the National Human Rights Commission under the Protection of Human Rights Act. It's now already documented, and several Indian Supreme Court is far ahead, even the compensation and other. That's one. In fact, when the Government of India has submitted the Universal Periodic Review this November 2022 in Geneva, UN Human Rights Council, always this question will come. In fact, you also are aware, the Government of India, when the Justice Venkatachalaya was the chairperson of the National Human Rights Commission, first time signed the Convention Against Torture, but so far has not ratified. This is all Government of India has to face, always at the international forum, that why don't you have signed Convention Against Torture? Why there is no definition of custodial death? But I am glad that this has now is part of this, which you could see in the mob lynching. And BNS attempts to address and curb mob lynching by criminalizing such acts as murder by a group of 5 or more persons on grounds of certain identity markers such as caste, language or personal belief, etc., punishable with 7 years of life imprisonment or death. This provision shall deter people from committing group crimes of this kind and promote social harmony and tolerance. Another one, the Bharatiya Nyaya Sanhitha 2023 also introduced the distinct category of culpable homicide relating to lynching. That's a section 103 class 2 of the BNS 2023 incorporates provisions for offences falling under the umbrella mob lynching. Community service I will not take. The next major thing I consider is the sensitive language. In fact, that is what is important, not only gender neutrality, but also the language. The one commendable aspect of the BNS is its use of sensitive language rather than the words like lunatic, idiot. Sensitive phrases like persons with mental illness rather than the insensitive words like lunatic, idiots. This is really a positive step. The term mental illness means substantial disorder of thinking, mood, perception, orientation, or memory that grossly impairs judgment, behavior, capacity. This has been now, it does not include mental retardation, which is a condition of arrested or incomplete development of a mind of person. You could see section 2S of the BNS, 2S of the Mental Health Care Act 2017 that is broadly interpreted and used in the sensitive language in the BNS. The broad definition covers almost all forms of diseases and disorders. You know, insanity, unsoundness of mind. We have been many years we have been following, and all English criminal jurisprudence we have been following. Next, 2 more and then I'll stop. Yeah, 3 more. Decriminalization of suicide. This is the debate whether the right to life includes right to die seems to have come to an end with the BNS not criminalizing attempt to commit suicide. We know Indian Penal Code 1860 criminalized the same with up to 1 year of imprisonment. Despite the constitutional validity of section 309 being upheld by the 5-judge bench of the Supreme Court in Keynote in 1996, it does not have a penalizing impact in the current times by virtue of the section 115 clause 1 of Mental Health Care Act 2017. And now this is something good thing which is being done in the BNS. It additionally casts a duty on the appropriate government to provide care, treatment and rehabilitation of the person. I think once somebody is in the mindset of the attempt to commit suicide should not be considered as an accused, and also this is something as a positive step has taken to provide care, treatment and rehabilitation. However, the offence has not been totally discarded, since a version of it is criminalized under BNS, where the intention is to compel or restrain a public servant from discharging his official duties. I think as Justice Lalit said, this is a little doubt. What is the intention? On one hand they have removed, decriminalized, and on the other hand a small portion is still remain. It is of course, but I would say that this is a progressive perspective and which is integrated into the penal statute. This perspective fosters a more compassionate society that seeks to understand and address the factors contributing to such behavior. Ultimately, we should aim in the holistic betterment of individuals and communities. As a criminal law teacher for more than 3 decades, what we primarily preach, teach, and we will try all our stakeholders that please remember punishment may work, may not work. Ultimately, rehabilitation, resocialization, and these are all the diversion. Several of the recent advancement in the community service needs to be followed, because we need to see that the whole new society has to emerge. The developments in criminology, penology have clearly demonstrated. So I think that's we could see in the decriminalization of suicide. New sexual offences, sexual intercourse on pretext of marriage or employment has been given the color of a new offence under BNS. Under the IPC, consent obtained on false promise to marry is not a valid consent as per section 90 of the IPC. But this is, we could see in 2019, the Supreme Court in Pramod Suryabhan Pawar versus State of Maharashtra called the attention in the difference between false promise and breach of promise. The former connotes the intention of the maker of the promise at the time was not to abide by it from the very beginning, whereas the later means non-fulfillment of a promise on account of something. The clear line of distinction is the intention of the maker on keeping up this promise. Therefore, section 69 of the BNS states, whoever by deceitful means or making by promise to marry to a woman without any intention of fulfilling the same and has sexual intercourse with her, such sexual intercourse not amount to the offence of rape shall be punished with the imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Interestingly, the term deceitful means shall include the false promise of employment or promotion, inducement, or marrying after suppressing identity. This newly created sexual offense has a broader ambit, and it's a positive step towards positive step forward, since it accumulates a focus on sexual intercourse on account of misconception, misrepresentation, false promise, etc., which is rampantly reported these days. We can see several of these cases we have been reported in the everyday newspapers and also some of the case laws. To establish these instances as a rape is neither easy nor justified. The degree of mens rea involved in such cases appears to be much less than that in the cases of rape, and therefore creation of a new offense altogether is better in all respects, such as spreading knowledge about the components of the crime, reporting of the crime, and establishing the guilt. Hit and run cases we have seen, which was introduced and later which has been taken away by when the final day has come. Grievous hurt causing permanent disability. This is, we could see section 117 clause 3 of the BNS 2023 introduces a stringent provision for acts causing grievous hurt leading to a persistent vegetative state or permanent disability. In such cases, the punishment is elevated to rigorous imprisonment for a term not less than 10 years, extendable to imprisonment for life, and this contrasts with the previous provision for grievous hurt alone, which carried a maximum penalty of up to 7 years of imprisonment. Now it is increased. This new provision reflects the increased severity of punishment for offence, resulting in severe and lasting consequences such as persistent vegetative status or permanent disability. Chain snatching, I think in the discussions when the CLRC was making, this was a major suggestion came from the police and the railway police particularly, how to tackle with the chain snatching. I think that's introduced. To conclude, the new Bharatiya Nyaya Sanhitha 2023 heralds a new era of legal reform in India, characterized by its commitment to fairness, accessibility and efficiency, by simplifying the legal procedures, enhancing the judicial infrastructure, and safeguarding the rights of vulnerable groups. This comprehensive framework holds the promise for a more equitable and responsive justice system. As India embarks on the transformative journey, Bharatiya Nyaya Sanhitha really stands as a beacon of hope for a more just and inclusive society. In conclusion, what I say that, but we must address not only just appreciating the new initiative, but also we must address the crucial aspects and the critical aspects. Where are the gaps, as Justice Lalit has pointed out? This is a time to think about and then see where we could, whatever the gaps, maybe sometimes it may happen during the either final drafting or some other cases, and that can be, we can see that slowly in the process we will try to remove these gaps and difficulties, and to see that, as Justice Krishna here always used to say, there is no soft justice syndrome towards the accused. Of course, we live in a rule of law society, fair and humane justice system, criminal justice system, police, prosecution, probation, all have to work together in the rule of law society. Constitutional fairness principles are more the objective which has to be followed. And with these few words, I will stop here, and thank you for giving me this opportunity to share my thoughts.
Thank you very much, sir. Sri Krishna Devaragaru enlightened us with regard to so many aspects, especially first time the transgender subject was covered under this new enactment. There is a punishment against the offences against the transgender, and especially gang rape and mob lynching also taken special care. They have taken it very seriously. Serious punishment also prescribed, like so many offences under the new act, taken care and elaborately mentioned, and the procedure and punishment also mentioned. So one way welcoming the new legislation, and now I request Madam Raishari Garu to address.
that we made, हमारा कानून जो हमने बनाया, it only took 163 years. We can now proudly say that the law is ours, we made it, and it belongs to us. Ladies and gentlemen, it's with great pride, immense pleasure, and utmost humility that I stand here among the greatest minds of the country, legal luminaries, officers who have done excellent work. I'm really glad to meet our esteemed senior Rajendra Kumar sir and experts from different fields and members of India Foundation for giving me this opportunity. I was a little worried what I should be talking in the presence of such great minds, and I'm so glad I came early so I could listen to the wonderful keynote address given by former Chief Justice of India, Honorable Lalitji, and all the esteemed speakers who spoke before me. It was a great learning session. I started taking notes, and for a moment I thought I should walk up to Apurva and ask him for his permission to attend this as a participant instead of a speaker. Because whatever I prepared in the last 24 hours, I think all the esteemed speakers have already covered it. So I would take this opportunity to speak out of my experience, what this law means to us, the police officers, as practitioners, as the ones in the field who are actually implementing it. So from the speeches of the esteemed personalities who spoke before me, one common thread, one common thought stood up. It stood out, and it was quite prominent in all the speeches. That is, after so many years of thinking about it, finally we made it happen. Finally we came up with our own law, and we made it so progressive that we shifted it from the punishment point of view to a victim point of view. It's a victim-centric law. When one of my esteemed panelists, Dr. Rao, was talking about it, in his speech he mentioned that Bharatiya Nyaya Sanhitha, it is Nyaya, it's not penal anymore. Nyaya is justice. So we have a law which is justice oriented. And I as a police officer, after hearing all of them speak, I think there is a great sense of responsibility that rests on all our shoulders to implement it in the right spirit. One of my former bosses always used to say, what is not monitored, it's not done. So it is our responsibility as police officers, as legal luminaries, as practicing advocates, and as members of think tanks, we have to ensure that the law is taught to everybody, every single stakeholder in a consistent manner, and we have to continuously monitor for many years. Finally, it takes its roots, and the real spirit, the real sense in which the new amendments have been brought, it's taken to the last person in the country. With this, I would like to very briefly talk about some salient features. Since the speakers have already covered the legal part of it, I will be going into the legal aspect of it. Things that personally I feel are going to be really great for the criminal justice system and the multiple stakeholders, and particularly police and prosecution, in terms of improving the criminal justice system, in terms of ensuring justice, and in terms of implementing the spirit in which this entire legislation was brought into force. So my understanding is that the whole the system of this new transformational jurisprudence that is before us today, it has few guiding principles, and I think the foremost guiding principle is that the purpose of punishment is to give justice. The purpose of punishment is to not punish somebody, but the purpose of punishment is to give justice to the person who has been actually wronged by a person or by an institution or by a group of people. So personally, I think a lot of speakers were talking about this one particular topic called organized crime. As a police officer, I was so glad that the new BNS is actually talking about organized crime in such great detail. They have gone to great lengths to define it. I think this is for the first time that it has been defined so beautifully that no police officer needs to read the law multiple times to understand it. I think Dr. Rao spoke about it, about this plain English movement that is going on. It was a new learning for me. I was not aware of it. when we read law, we have the Criminal Major Act and the Minor Act, and we always carry the little booklets with us. And when I read, I don't understand most of it because the legal language is so hard. Even for somebody like me at a leadership position, I can only imagine how hard it is for a SHO at the police station level to understand this language. So most of the time when we have this monthly review meeting with the Honorable Principal District Sessions Judges, they're always so mad at us. They say that this charge sheet has like so many mistakes. These mistakes have been pointed out in the past, but they keep repeating it. I mean, every time there is a review meeting, the first 1 hour is spent in only telling us that how badly we prepared the charge sheet and how badly we submitted before the Honorable Court. Why this happens? Because the language is so hard for the police officers to understand, and the prosecutors, the public prosecutors probably are not able to sensitize or educate given the volume of work that happens in the police station level. So now I think it is a great opportunity for us. I always tell my subordinates that the moment we start wearing the uniform, I was told this by my seniors also, that the unlearning happens. You learn so much for the civil services examination, for the state services examination, for the sub-inspector recruitment examinations. You study so much, finally you crack the exam, get into the service, get trained, wear the uniform, start working, and then you stop learning. You're not learning anymore. Now, finally, the country has given us an opportunity to start learning again. So, a lot of attempts have been made by the Telangana State Police also to start very detailed training sessions in a consistent manner for all the officers. The newly recruited constables who have just started training in the Telangana State Police Academy, they were given a very detailed session by one of the former special director from CBI on the new laws. And I think there are efforts taken by many state police organizations to teach the police officers. But in this, today, in this moment, I would like to express my desire that everybody who is sitting here, you are the main stakeholders, and I think it is for us to come up with a mechanism to ensure that this is implemented properly and this is taught properly, sensitized properly, and the sensitization should not just stop with the police officers or the legal practitioners, it should be taken to the citizens as well. And I think we also have a responsibility in that. I am requesting my subordinates also to use the community outreach activities that happen at various levels in the police organizations to talk about the new laws and educate the public as well. And the second thing, important guiding principle is the primacy of Indian interest. Justice Lalitji spoke about it in great detail, that finally we have a law which adheres to the constitutional values 100%, 200%. There's no question about it. When the law on sedition was called into question, there were multiple conspirational theories, there was a huge resistance, and different stakeholders raising concerns. And finally, everything, all the concerns have been put to rest. Now we have come up with a law which has addressed all these concerns, and we have clarity. I think in today's legal world, in today's police world, what we need is clarity. So this is very important for us, that the law is made by our own parliament, and it has adhered to every single principle given by the great constitution of this country. And I am so glad that today this session is all about Chapter 5 in the Bharatiya and Nyaya Sanhitha, which only talks about crime against the body and women. And for the first time, they have gathered all the sections which was dealing with crime against women and crime against children, and they have brought it under one umbrella, which is Chapter 5. So we are going to start the training with Chapter 5, because that is what we deal with almost on a daily basis, crime against the body and crime against children. So that is the highlight of the second principle. And like I said in the beginning of the speech, victim-centric laws. Now we are going to promote zero FIRs in a really big way. One of the major concerns of the citizens is that the moment they walk into a police station, FIR darj nahi hota hai kyunki hamara jurisdiction nahi hota. It's not our jurisdiction. You go to the next police station. The person goes to the next police station, that SHO says, this is not my area, go to the next police station. So running from pillar to post. And this has been a major concern. All this while, and in certain states, they have already started implementing zero FIR. Telangana State Police is already doing it. but still there's a lot of awareness that needs to happen, and it needs to be mainstreamed into the routine policing activity. So this law gives a lot of strength to that zero FIR system and also the e-FIR system. Within 24 hours of filing of registration, we are supposed to inform the honorable magistrate, and now it can be done electronically as well. And now the new law also gives a lot of importance to faster trial. I think there are clauses which talk about a certain time period which is given to the magistrates also to conduct the trial in a timely manner. And progress of investigation and withdrawal from prosecution, everything is dealt in detail. Now, the zero tolerance to terrorist crimes and organized crimes, which was spoken in detail about the esteemed speakers, like I said in the beginning, it has been defined so beautifully that there should not be any confusion. You must already observe that of late, the crime landscape is slowly moving from this physical space to the digital space. In our day-to-day dealing with the cases, we have observed that today every crime that is being registered in a police station has a technology component to it. It is connected to cybercrime, even if it is about a complaint given by a girl of stalking. A person is stalking. If you know, earlier in the past, a girl is being stalked in the physical space. The person is following her into the college, following her to the temple, waiting for her at the bus station, and then making her quite uncomfortable in the physical space. Now, it has gone to digital space. The ramification is much bigger. The mental torture the victim goes through is much bigger because he can be consistent at it. It is faceless. You can be anonymous and still be the perpetrator, and it's very difficult to, for the criminal justice system to bring him to justice. So today, in these chapters, every single crime, Dr. Rao has given the list of it, every single crime is given a detailed definition, what amounts to an offense, and what is the offense, and the investigating officers have been given a certain timeline, and proper standard operating procedures have been put in place to tell how we are going to record the statement of the victim, how we are going to collect evidence, how we are going to give a copy of the FIR to the victim. In every stage of the investigation, this new law is talking about the rights of the individual, rights of the victim, and also the rights of the accused. And the last and the most important guiding principle is a modernized police department, a modernized prosecution system, and modernized courts. We have come up with new technologies. Forensics is given a lot of importance, and there are new forms of punishment. The speakers have already spoken about the different types of punishments that will be implemented in the new law. I will only talk about the forensics because currently I am dealing with it. Just yesterday, my boss has given me a task to study the latest state-of-the-art mobile forensic vans. And when I was going through the specifications given by the Ministry of Home Affairs, I was so surprised at the length to which the ministry has gone to foresee the future challenges that can happen to us, and then provide us with an infrastructure, provide us with equipments which will help us deal with those new age crimes. So today, most of the state governments, all the state governments have been given adequate funds, adequate budget to procure state-of-the-art mobile forensic vans, because the new law also mandates that any crime having 7 years of punishment is right. The forensic expert must visit the scene of crime. It is mandatory now, but I think there is a time period of 5 years that is given to the state governments to come up with their own mechanism or some set of laws to procure or to go for more hiring and recruitment of forensic experts. But now, since this clause is mandatory, that the forensic team of experts have to visit the scene of crime, it gives a lot of evidentiary value to the investigation process. Ultimately, it is going to improve the conviction, and ultimately it is going to do justice to the right spirit in which the law was brought into effect, that is, giving justice to the victims, victim-centric approach. And since I was requested to talk about crime against women, very briefly I would like to just list out the highlights in chapter 5. I already spoke about a separated, dedicated chapter that is being given to all the crime against women and children. They have been brought under the same umbrella, making it easier for us to understand the law and then implement it, and the provisions of EFIR and zero FIRs. An offence is largely made gender neutral. I think the state speakers have already spoken about it: male, female, transgender. And this is more important because somebody was already speaking about it. When this aggravated sexual act is committed against a child, or a child is particularly trafficked for the purpose of being forced into illicit sexual intercourse or acts which are not supposed to be done by a child of that age, there was no clarity, there was no sensitization, there was lack of awareness in almost even today. There's a huge lack of awareness among all the police officers about how we are supposed to handle this issue. There are two challenges. One, this is like a post secret because of the very social fabric of our country. People don't really talk about the sexual offences committed against children because I think in most of the cases the perpetrator is somebody very, very close to the child. Sometimes it's an uncle. There have been so many cases where we have dealt with the father impregnates a child which is of just 13 years of age, and an 8-year-old boy is sodomized by the uncle, or to the extent of killing him or murdering him. So in such cases, most of the time the family is unwilling to come forward because of the lack of safeguards which is there for the victims. There is no witness protection mechanisms in place. Today the law is talking about witness protection. It is for the states to come up with mechanisms. So I think this definition of making the offences gender neutral is going to revolutionize the way in which the investigation will be done. And publishing court proceedings revealing identity of victim of sexual offences without court's permission, it's made a punishable offence now. Otherwise, you must have seen in the rush to give breaking news, a lot of social media-based news outlets are just blatantly giving the name of the victims, and it's like a secondary punishment for the victim. It's secondary victimization. The offence is already committed against the victim, and they are already going through the trauma of it. Now we are flashing the name across all the news outlets, making it so difficult for the victim to come out and lead a normal life in the society. Death sentence in case of gang rape of minor. The new law specifically states that if gang rape is committed against a woman less than 18 years of age, there will be life imprisonment. I think there is 10 lakhs fine also. Buying, selling, hiring child for employment, prostitution made a punishable offence. In this last point, I would like to give a small example, and then with that I will conclude my remarks here. Now, as DIG in Women's Safety Wing, we are dealing with this CSAM, the issue of CSAM, child sexual abusive material in online spaces, in the digital platforms. I was really surprised to see at the volume of CSAM material that is being circulated, sold, created, and shared in the different, in different digital media platforms. It is like a thriving, but with this new law, now we know what is that we are supposed to do in order to stop this. So with this, I'd like to thank India Foundation and Nalsar University for giving me this opportunity, and thank you so much, and thank you so much for giving me the opportunity to learn from all the esteemed speakers.
Really, we are happy for introduction. You differentiate the IPC with the Bharatiya and Nyaya Sanhitha. That is Nyaya instead of penal. Really wonderful interpretation. And Madam, in addition to so many offences, especially she has explained the offences against women and children. In day to day, we are seeing in India this gang rape and mob lynching. So, especially they have taken care along with other offences. Anyways, we have to see this in a positive manner. It's a positive legislation. So, I have to welcome all this. And because Madam was expressing initially, she was hesitating to start her speech saying that so many learner persons Madam, we are fully on other side, civil side. We are learning here, being with you, with your experience. One example I give, I don't want to take much time. When Domestic Violence Act came into force, the litigant public, educated advocates, they were in totally dilemma. In addition to matrimonial laws, so many matrimonial laws, how to apply, where to apply these provisions like that. So to clear that confusion, we conducted a big seminar in the criminal court, Nampalli. At that time, Senior Judge Ravini was there, she presided. Like that, so many seminars were conducted. Now, we are fortunate to have Krishna Devarao Garu from Nansa side. So, we will conduct in future programs. We should be there, sir, to take up the responsibility to explain about the provisions of this legislation. Anyway, if somebody wants, at least for their clarification, they ask one or two questions. The speakers are there. They can come and question. Ask any question for their clarification. Please. Nobody is there, we can come from there. Somebody is there? We can conclude this session. Anyway, especially on behalf of India Foundation and NALSA, I'm very much thankful to the respected speakers of this session. Thank you, one and all.
Thank you, sir, and the speakers for an excellent session. May I request Professor Veerababu Garu to come onto the stage and kindly felicitate our speakers on behalf of the organizers. Professor Veerababu Garu felicitating Sri Krishna Devarao Garu. One more time. May I request Bhavya Gujral, round long of applause, please. Bhavya Gujral, may I request you to kindly felicitate Madam Rema Rajeshwari. May I request Mrityunjaya Roy to kindly felicitate Narasimha Reddy Garu. Mrityunjaya Roy. Thank you, sir. May I call all of you for a group picture? So may I request you to stand for a group picture?
Sir.
Thank you, sir. We start with the next session right away. Kindly hang on.
భలే ఉంటుంది రిపోర్టర్ ఆయనకంటే ఒక ఛానల్ ఉంది.
Move on to the second session and the final session of this symposium on the Bharatiya Sanhitha. This session is on crimes against the state, and we have two very distinguished speakers, an equally distinguished chair to guide the discussions in this session. To chair this session, may I invite Shri K. Rajendra Kumar, former DGP Jammu Kashmir, to please join us on dais. One of our most distinguished police officers who handled some very, very difficult insurgency situations for our class. It is an absolute honor to have you chair this session. As the two speakers, let me first call upon Professor Balram Chauhan, former Vice Chancellor of National University Bhopal, National University Lucknow, and the founding Vice Chancellor of Ramchander National University Jabalpur, currently working as a state lead in Uttar Pradesh in a think tank called PRISM. Sir, please join us on dais. And next, may I invite Shri Vikramjit Banerjee, Additional Solicitor General of the Government of India, and the Advocate General, former Advocate General of the Government of Nagaland, to please join us on dais. Before I hand over the session to Shri K. Rajendra Kumarji to kickstart the discussion and guide the conversation with the speakers, let me just say what a deep privilege it is and a matter of personal pride for me to be inviting two speakers with whom I have a personal connection. I was a student of Professor Balram Chauhan, and Vikramji Dada has been a mentor to me since the start of my career. So, thank you. With those words, may I request Rajendra sir to please take over the proceedings. Thank you.
Good afternoon to you all, ladies and gentlemen. It's my proud privilege to chair this session on offences against the state. Now I know all of you must be, it's a dry subject. Law is always a dry subject, and during our training, we used to fall asleep whenever the law class was scheduled. After a heavy morning schedule, 3 hours of physical activity on the course, most of us used to snore off in the classroom, and the law used to be with books, open books. So we managed to get through. Having said that, I'm extremely grateful to India Foundation for extending me this invitation to chair this session. Initially, when I was asked to chair this session, I said I'm least qualified to speak about BNS, a new law, the new 3 criminal laws that have been passed by the Indian Parliament. While I belong to the old school, I'm a creation of 19th century. As I talk to you, I'm a creation of 19th century policeman, 1861 Police Act. I also implemented the same 19th century law, trying to provide a world-class service to the 21st century Indian citizens with the 19th century tools. That's what I am at the moment. So when I was asked to chair, I was very reluctant. Then I was told, no, you don't have to speak anything. You just have to listen. That's what my learned friend, Mr. Ramchander told me, for which I agreed. Having heard everyone here, being the last one to chair, I am practically left with nothing except to repeat what all has been said. However, I did prepare myself to speak a few words on the topic I did go through. Having a separate constitution, a separate flag, and separate criminal laws. I learned the IPC, I learned the Criminal Procedure Code of India, and I learned the Indian Evidence Act. And to my horror, I was allotted to the J&K cadre, where I had to operate under a different constitution. J&K had a different constitution prior to revocation of Article 370, so we had a different constitution. Instead of IPC, we had the Ranbir Penal Code, we had the Criminal Procedure Code, and we had the Evidence Act of Jammu and Kashmir. However, mercifully, most of the sections are corresponding. Now you have a system wherein a new law, the colonial laws have been repealed. Our own laws, which are transformative and progressive in nature, have been introduced and have been notified, which will be coming into force from 1st July 2024. It came very suddenly. It has caught the legal practitioners and everyone mostly by surprise, because we were not really prepared, though we were pushing for it. We were pushing for the reforms in the criminal justice system. And these things cannot, the criminal justice reforms cannot happen in a vacuum. It has to be, simultaneously done in conjunction with the police reforms, the ones who need to implement them on the ground. My earlier colleague spoke about the difficulties in the forensics. Are we ready? Do the states, police and public order being a state subject, do the states have the sort of infrastructure that is required in terms of the forensics, in terms of the digital evidences that need to be collected, the inequalities between various states? Though the government of India funds heavily under the modernization of police forces, but yet the states need to pump in additional resources for having these systems in place, be it the prosecution, be it the training, and finally the will. The will on the part of the police forces, the mindset, they have been used to it. Like I said, I belong to the 19th century. For me to catapult into the 21st century, I need as a policeman the motivation, the will to get into that. Now, with this, I would not like to waste much of the time. I would like to say that when we talk about the offences against the state, in the old laws, in the IPC, it was under Chapter 6, which talks about, especially talks about sedition. Whereas in the new laws, it comes under Chapter 7. So in the old laws, it is from 121 to 130, and in the new laws, Chapter 7, it covers from 147 to 158. The laws are almost same. 70% they're similar. The only thing is the sedition word has been deleted. However, I am the happiest man. Having faced the brunt of offences against the state, I don't think any other state has gone through the turmoil which the J&K state has gone through, with thousands and lakhs of youth getting radicalized, going across, coming back, waging war against the state. Though we had certain laws, the special acts, under the CADA or POTA. I don't know how many of you have heard about POTA. We started off CADA with CADA. The state government may not be willing to implement the CADA because of the Article 370. It's up to the state government. Because some of the laws say this law enacted on such and such date applicable to whole of India except the state of Jammu and Kashmir. That is where that's what pinches you very badly being an Indian going from here. You think this law is not applicable. Your own law passed by your own parliament is not applicable a part of the country which is integral to India, and yet it's not applicable there. But the government just refuses to implement the quota. In fact, the elections have been fought on the premise of not implementing quota if such and such party comes to power. And that is the extent of, dichotomy we had in the laws. Now with one stroke of pen, this particular BNS, Bharatiya, Nyaya, Sanhitha, has bridged that gap completely and made the law completely uniform. Now with this, I would not like to stand much between you and our illustrious speakers. First, I would like to invite Professor Balram Chauhan to come and deliver his lecture. Thank you very much, ladies and gentlemen.
Very good afternoon to all of you. Distinguished dignitaries sitting on the dais, off the dais, esteemed colleagues, dear participants and students. At the outset, I would like to thank India Foundation as well as the Vice Chancellor of Alsar, Professor K.D. Rao, for providing me this wonderful opportunity to be the part of this conference. Believe me, it is one step which will bring several good things in future. Why I am saying so? The legal framework in India is on the brink of substantial transformation with the impending implementation of the new criminal laws. We are discussing Bharatiya Nyaya, and there were discussions about Nyaya. You see, justice is a philosophical term. Honorable judges who are sitting here, learned advocates who are sitting here, every day you are fighting for the cause of justice. But this justice is not that justice about which we are talking in the Constitution. When we talk about the justice in law, then we mean to say that it is the duty to find out the best element of law. It is duty to find out what is just in law as well as in equity. And according to me, this is the first requirement for the proper implementation of Bharatiya Nyaya Sanhita if you really want to make this Sanhita successful in the future. Second, I don't know, yesterday evening when I was just thinking, I was received by one Yashwardhan, Mr. Yashwardhan, intern. Thank you, Yashwardhan, for doing all good things for me. And I wanted to ask that question, but I will ask in the last. But the discussion which I had with him, it reminded me, first law commission, there were 3 members, Macaulay, Millet, MacLeod. 3 M's. MQ. They drafted the Indian Penal Code from 1834 to 1838. Then, of course, Peacock revised it, and then it was enacted in the from 1st January 1862. But again, another M has introduced the new Bharatiya Nyaya Sanhita. Don't you think there is a role of this M alphabet more as far as the criminal justice administration in our country is concerned? It is on the lighter side. Think about that. Millet, Macaulay, Millet, MacLeod. What I am trying to say, when I reviewed this BNS, I found that now it is having 356 sections against the 511 which it was consisting previously. A meticulous review revealed that in this Sanhitha, 175 sections have been changed. They are the same, but some changes have been made in those sections. There has been incorporation of 8 new sections, only 8 new sections, and the deletion of the 22 sections. Friends, remember, this code was drafted in pre-colonial era because the power was transferred to the government after 1857 Great Mutiny. Before that it was pre-colonial era, but it was enacted in the colonial era. And the topic which I am going to discuss is offences against state. Initially, when the code was enacted, there were 10 sections from 121 to 130. Afterwards, in 1870, an amendment was made, and section 121A and 124A, they were added. Again, one amendment was made in 1898, and in 1898, the present law of sedition, this section of sedition, it was substituted, and the old one was removed. So, in new Bharatiya Nyaya Sanhitha, the same framework, 12 sections are there from 147 onwards. And we have changed only one section. And we are having the discussions, and I'm happy that many law students are sitting here, and our former DGP of the Jammu and Kashmir was talking about the offences against state. I got the several opportunity to visit Jammu and Kashmir University several times, and those were the days when we were talking about the one nation, one law, and so many things were there. Even the Juvenile Justice Act was not applicable. And so better we should not take that as an example as far as now things are different. We are having one law and we can discuss it. What I mean to say that if we look towards this chapter, there are 4 principal offences. Mind it, 4 principal offences in this chapter, and they are waging war against the government of India, section 121, 121A, 122 and 123. Waging war against any Asiatic ally of the government of India, section 125, section 126 and section 127. Overawing the government, section 124 and 124A, and permitting or aiding the escape of state prisoner or a prisoner of war, section 128, 129 and 130. Friends, except section 124A, which is now 152, all other sections, their language, order is the same. Professor Rao was mentioning that he was a member of the Law Reforms Committee, and we discussed, debated, we argued, and that was an opportunity for all of us to read the recommendations of the Law Commission, whether it was the recommendation of the 42nd Law Commission or it was the recommendation of the 159, and especially the Criminal Law Amendment Bill of the 1978 that also proposed fewer changes, but they were not made out. As a member, first thing which we noticed, I will not say we noticed, 0.004% offences were falling in the category of the offences against the state. And again, that major chunk of these offences was, as you know, about the offence of sedition. So ultimately, because I will not go into detail what were the recommendations of the Law Commission and how the UK has deleted the law of sedition and what was the futuristic goal as far as all of us are concerned. But one thing I would like, in 2021, and that is a issue which I wanted to highlight before you, and it is not for the sake of only research and other things, but I think everybody, all of us, want to eliminate the Ravan from the society. Criminal law is a tool, criminal law is a source through which we can eliminate the Ravana. Ravan, मैं कभी-कभी हिंदी में देर में कंप्लेंट हिंदी किस रावण की भुजा उखाड़ूं कहां-कहां मैं आग लगाऊं जन-जन रावण घर-घर लंका इतने राम कहां से लाऊं. We in life schools are creating dramas. All students who are sitting here in front of me, thank you, Apur. You mentioned me. I forgot about you because, frankly speaking, I don't remember. But of course, now I can place you. So, making a drama, KD now is involved. All the vice chancellors and the law schools are trying to do this thing so that criminal may be punished through the law, and the law must be such. Because I was asking, sir, one I think I could just was sitting just by my side, and I asked him one question because yesterday evening, Yashwardhan asked me one question. Sir, in IPC there is section 377 regarding the habitual offences. It's true that in one of the Supreme Court case, Dr. Johar, consensual relationship has been put beyond the scope of 377. But what about the other unnatural offences? What about the forceful relationship? There is no corresponding section in the new Bharatiya Sanhitha, and I think Dr. Rao will look into the matter as far as the offences against body are concerned. And thank you, Yashwardhan, for raising this very important issue. And I was expecting that you will ask this question, because that is the purpose of this conference. Second thing, because of this sedition cases, because I have collected many cases for the sake of information, for the sake of the future of our Bharatiya Sanhitha, because Justice Lalit Saab was mentioning about some cases of the era of the pre-independence. In some late judgments directly following the implementation of the section 124, because I think these are the important cases which everybody should read, who is interested in the futuristic success of our laws. Queen Emperor versus Bharatiya Tilak, this was discussed by him. Queen Empress versus Ramchander Narayan, 1898. Queen Empress versus Amba Prasad, 1897. The question was when the criticism or disapproval of the government would constitute the sedition and when not. That question, which is even today. Thus, the British government used the section in full swing to frame freedom fighters like Mahatma Gandhi, Abdul Kalam Azad, V.D. Savarkar, and Bal Tilak. Then in 1935, the court came up with a landmark judgment that stepped the British advancements. I found a very good case. And that was decided in 1935 in Kamal Krishna Sarkar versus Emperor. The court refused to hold the criticism of the existing government in the suggestion of other forms of government as seditious. Again, the scope of sedition was narrowed down in the Nehru Dutt Majumdar versus the King Emperor. You see, Judges have played a very important role as far as the, I will say, human rights. Those were the days when we were not talking in terms of the human rights, but liberty, equality. These principles are reflected in some judgments. Sarkar case is very important because at that time, such type of judgments were fresh blow of air. However, all this jurisprudence got reversed in the court's verdict in the King Emperor versus Sadashiv Narayan Bhalerao in 1947, the year in which we got independence. All these judicial improvements were nullified by this judgment. And I think First Amendment, what we had in our Constitution in 19+2, such misuse of sedition law is what prompted K.M. Munshi to move an amendment against the draft Article 13 in the Constituent Assembly, which related to the right of freedom of speech and expression and included sedition as an exception to this right. This led to omission of the word sedition in the final text of the Indian Constitution. The Indian Constitution may be a sedition, this word was going to appear, but it was removed. However, the law on sedition was indirectly reimposed and re-strengthened by the First Amendment Act passed by the government in 1951. Through an addition of the expressions friendly relation with the foreign states and public order under Article 19 as valid reasonable restrictions on the right to freedom of speech and expression. Friends, a glance at such a rocky past of sedition in India prompts one to realize the inadequacies as well as the purpose of this law and makes it inevitable for one to question the desirability of such law in present cases. After independence, 52, Justice Lalit was saying that we are going to bury the ghost. But lawyers are sitting here, honorable judges are sitting here. I know it will not be possible so easily. That ghost will hang on our heads. My friend, Mr. Banerjee, is smiling. You see, the post-independence judicial deliberations on the constitutionality and the scope of sedition have a contrasting history. The first instance when Section 124A came into scrutiny was in Somesh Thakur versus State of Madras, where the Supreme Court held that unless the freedom of speech and expression threaten the security or tend to overthrow the states, any law imposing restrictions upon the same would not fall within the purview of Article 92 of the Constitution. Further, two different high courts in Tara Singh Gopichan versus the State of Punjab, 1951, Ramchander versus State of Uttar Pradesh, 1959, overturned the sedition law and held it ultra vires of the Indian Constitution as it curbed the freedom to put forward one's views and opinions. Besides, the High Court observed that a law of sedition, thought necessary during a period of foreign rule, has become inappropriate by the very nature of the change which has come about. The precedent in question in the present case is the Kedarnath Singh versus State of Bihar, a landmark judgment. I need not to elaborate on this particular judgment because everybody knows about it. The question is, the Supreme Court posed the judgment in merit cases. A mere act of dissent has been curbed under the aegis of the draconian law. The Supreme Court in Balwant Singh and another versus State of Madras, 1995, held that mere chanting of slogans like Khalistan Zindabad, Raj Karega Khalsa, etc. did not constitute a seditious act, as there was no evidence. Similarly, I collected so many cases, and especially the case of Vinod Dua, Rajat Sharma. You all know about these cases. But in 1920, in Patrika Mukhim versus State of Meghalaya, 2021, the Shillong Times editor, that case when came to the light, I think all of you might have read about that, and you would have expressed your opinion on that particular case. Similarly, the Disha A. Ravi versus State of Delhi, NCT Delhi. Mainly, I would like to discuss this case of Justice Ramanna, because in 2021, Justice Ramanna Saab passed judgment almost 10 petitions were filed challenging the constitutionality of the sedition law, which were all clubbed by the Supreme Court of India in the case of S.G. Bombakere versus Union of India in 2021. A 3-judges bench led by the Chief Justice N.V. Ramanna was constituted, and their latest order in the case is what represents the fresh judicial stance on the issue. The court expressed its prima facie opinion that the clause on sedition, I quote, is not in tune with the current social value and was intended for a time when the country was under the colonial regime, unquote, and asked the government to re-examine the said provision. Until then, the Supreme Court has put the impugned provisions on hold and directed the government to keep all pending trials, appeals and proceedings arising out of Section 124A in abeyance. Effectively, in the interest of justice and the provisional relief, the court suspended arrest, allowed bails in an otherwise non-bailable and cognizable offences, which it believes is being misused to frame people. Thus, the present order of the Supreme Court seems to be revolutionary. But sir, believe me, whenever I am discussing this case with my students, they are asking me 2 questions. Sir, why this matter was not referred to the 5-judges bench? How an order can be passed by the apex court to release the accused on bail in non-bailable offences? Because, but I said, when you see under Article 142, complete justice, it is the power of the apex court. So, I will only say that now the things are going to be in a new direction, and Section 152, what we are having today with us, I would like to read that in front of you. Either spoken or written, or by signs, or by visible representation, or by electronic communication, or by use of financial means, or otherwise excites or attempts to excite secession, mind my words, secession, or armed rebellion, or subversive activities, or encourages feeling of separatist activities, or condemns sovereignty, unity and integrity of India, or indulges it on commits any such act, shall be punished, then the punishment is there. These are words. What are the subversive activities? Justice Lalit was telling that as far as the unity integrity is concerned, it's okay. Other activities. So I hope that this law will provide a solution for most of the problems what we were having. But one good thing has happened. The name of sedition has been removed from the statute book, and we hope that now the rights of the people will be respected, and we will be having a crime-free society in future. I thank once again the organizers for allowing me and standing before you. Thank you very much.
Thank you very much, Professor Bharatiya. That was a very, very illustrative and educative speech. He has spoken extremely well about the number of, the sections that have been clubbed together, brought down from 511, that has been brought down to 356, the 4 principles of, the entire sedition. Then he has spoken about substantial transformation. And then a very interesting thing, the criminal law is a source to eliminate the Ravanas in the society. And of course the sedition law which was upheld in 1962. Now before I offer the mic to the next speaker, Mr. Vikramjit Banerjee, Honorable Additional Solicitor General of India, I have a doubt because I am also a learner now. With the Supreme Court placing a bar on registration of cases under 124A and the new act which is just notified and yet to come into play from 1st July. So what happens to such acts committed now? Can I do any act which endangers the unity, integrity and sovereignty of India between now and July 1st? Can I get away with that? Now this question I am throwing to the next speaker, Mr. Vikramjit Banerjee. The mic is yours now.
Thank you, Balraji. Thank you, Rajendraji. When I was asked to speak on this topic, especially on the crimes against the state, my take on that is this, that we have the IPC, we know the provision of the IPC, 124A, and I'll go through the history of why that came into being. But most importantly, I think the crux of what we need to discuss is finally what, as Justice Lalit said in the morning, finally how the act is worked out will be worked out by the courts. So it will be worked out by you, by the public prosecutors all across the country. So that's a separate issue. But what is the difference in approach in this conception of sedition, and how should we look at the new provision? My suggestion to you is that there is or has been a jurisprudence on sedition under the IPC 124A because of its history. And that history, as we'll go along, is intricately linked to the colonial struggle. So whenever we look at that provision, we look at it in two ways. We look at it as a colonial imposition. That's one, because that was the clear intention. There's no doubt about it. But we also look at it in context of the number of freedom fighters who were arrested under those provisions. So our mentality of how the jurisprudence of these provisions are shaped actually by our experience of that provision. Now, of course, number of judgments, number of things saying that you dilute the provision and you don't look into it and you look at it afresh. Fine. But what I think is when we need to look at the new provision under the Nyaya Sanhitha or the BNS, we need to look at it with the mental approach that you are looking at it. How would the new India look at it? And the new India faces some of the problems which the British did, the colonial state did. Maybe exaggerated in the, maybe even more in context of, the internet, in context of the means of communication, in context of various different things. I think I to a certain extent disagree with Justice Lalit when he said that maybe it's better that terrorism existed outside. I think it's a good thing it's part of the BNS or the penal code, which I generally speak about. I think it's good that it's been incorporated because the consolidation of criminal statutes is extremely important. That being said, I'll come put that in context and then come to what my major talk or whatever this small thing is about. The changes of sedition which Justice Chauhan spoke about, and subsequently it was changed again once in 1898, what came in 1860. It came after the First War of Independence in 1857. The approach in 1860 was specifically made because this was, I think, the first act, first provision when the British state realized that the old powers whom it had worked against in 1857 were dead. The princes were gone. The old world of feudalism in many ways which they were used to was dying, had no future. So it had to actually now address the next question about people's objections against the government. So it was brought up in that context. Very many people say it was brought up in different contexts. And some say because there was an outpouring after 1857, people were then slowly coalescing into a movement which would go against the colonial government. So it came up with that. Now, and it was used extensively in India. And after that, it became like hugely extensive. It was as I think Justice Lalit said, as Professor Chauhan said, it was used against Mahatma Gandhi. It was used against Lokmanya Tilak very, very famously. And I'm from Bengal, and I know it was hugely used against every small type of Bengali nationalist newspaper which ever came out, worth its salt at that point of time. And against Bande Mataram, which was a newspaper, against Jugantar, which was another newspaper. So it was used extensively, even small newspapers, it was used very, very extensively. Now, therefore, when the matter came up before the Constituent Assembly, and that is what Balrajji marked, there was a discussion as to whether you should have sedition as an exception to freedom of speech in the Constitution. Sardar Patel was of the view that it should be an exception. K. Munshi opposed it, and it was dropped. Now that, as Balrajji said, was not the end of the story. Within a year, the amendment was brought back through the First Amendment. And any one of you who wants to read about this, you should read a book called Those 7 Stormy Days. It's a wonderful book on how this entire debate in the Parliament which happened, where there was this very, very famous exchange between Jawaharlal Nehru, who was obviously wanted to bring these provisions, and these provisions, subsequent amendment went through, and unity, anything against the unity, integrity of India was brought in, so it was brought in another way. And Shama Prasad Mukherjee of the Jansa. And it was Shama Prasad Mukherjee who opposed these amendments. And there was this very, very famous exchange at that point of time. And I don't want to go into the details, where Shama Prasad Mukherjee is very famously noted to have said that I think the word was, this was, I think the argument was, this will crush those who are working against the country. So Shyam Mukherjee went and made a law argument saying that this attempt to crush your opposition is what is ailing this government. I don't want to go into the details, but I said, I will crush your crushing attitude towards, for the people. But anyway, so that was a huge debate. It went through, and as a result, you had an exception carved in the freedom of speech and expression for broadly this question of sedition by another names. And sedition, which was 124A, which is brought in by an amendment to the IPC. It originally does not exist in the IPC, as Balraji said. It was brought in 1860 at a later point in time, because it was brought in when the British first sort of faced this pushback after 1857. Now, some of the major cases which was discussed, I'll just flag it, was one is Jogendra Chandra Bose, where the entire conception of sedition law was upheld because it was challenged, saying this goes against the rights of the people to speak their mind. So the courts upheld sedition law, saying that it was important. And the court, if you've seen the sedition provision, you would know that there is a provision, part of it, this latter part of it says, you can, disaffection is something called disappropriation. Disappropriation is against the government and its policies. So since that is allowed, so it doesn't go against the right of people to speak out. Of course, subsequently, as Justice Lalit spoke about, there was Bal Gangadhar Tilak, and King Emperor versus Bal Gangadhar Tilak, very, very famous case in the history of India. So the ultimate objective is, subsequently, of course, he was convicted, Bal Gangadhar Tilak, Lokmanya Tilak was convicted, and the court said that it doesn't matter what your intention was of the speech, but as long as it sort of, creates disaffection amongst the people. If you see the sedition provision, the whole question is something which creates disaffection, and that is a colonial approach, because disaffection means disaffection against the government. Now, if the government actually belongs to the people, you can't create disaffection against the government. So I think in many ways this change is very relevant. Next is, of course, as what Justice Lalit spoke about, is Kedarnath Singh, which actually came down back into the original arguments made in Tilak and subsequently, and so that you can't use sedition to clamp down on freedom of speech. But Kedarnath Singh is post-independence and during another very tumultuous time. And then Balwant Singh, which comes at the time of, or right after the Khalistan movement, where they said that as long as it's just a speech and does not affect or change anything on the ground, does not have a practical impact, does not provoke people to do something, it should not be classified as sedition. In many ways, there is back and forth on sedition. Sedition is a tough charge, but the courts have actually, my personal perception is it's in many ways diluted sedition. That being said, and this is my take on the future of how we need to interpret these provisions. If you look at fundamental rights of the Indian Constitution, fundamental rights in the Indian Constitution is substantially different from American approach to constitutional law. The American conception of fundamental rights is fundamental rights are absolute unless you can carve an exception, and these are exceptional exceptions which are carved out. Indian fundamental rights are by nature, from the very inception, restricted rights. And the reason why, I'll give you 2 examples. Number one, even Article 21, which is right to life, as it was originally framed, not what was interpreted by the Supreme Court, said you can actually deprive a person's right to life, if it is not even due process, except through procedure established by law. So it didn't even have a due process clause. I mean that it doesn't matter if the act was good, bad, oppressive, as long as there's a process established by law, you can deprive a person's right to life on that ground. So it has always been a restrictive, to that extent, fundamental rights. Fundamental rights of freedom of speech and expression has always been subject to restrictions, reasonable restrictions. And the present, and what the First Amendment did, And right at the inception was it specifically put into ground. Sovereignty, integrity, security of the state, friendly relations with other countries and foreign powers, public order, decency, morality, contempt, defamation, incitement. These are exceptions. So these are carved exceptions into your fundamental rights. So if you take interpretation arising out of the Constitution per se, you have to look at any provision, which is not only sedition, which subsequently replaces sedition, you have to look at it in those terms. Now, the reason for, why, again, I don't have to go into this, but I'm just indicating the reason why we had this balance is because we know our Constituent Assembly knew for a fact that India is a very, it is a very sensitive country. People have very sensitive ideas, and so about their society. So what in America goes as free speech and people can say things without consequences, in India ideas and words have consequences. People get hurt, communities get hurt, which eventually result in violence. So it's, a statement is not merely a statement. A statement has consequences. And we, in many ways, being in India, we have seen the impact of social media of that. The social media comes from a very American point of view, like Twitter, like Facebook. You can say whatever you want to, but in India, in fact, the problem which we see, the new framing of the law which we see comes because of these new challenges of technology, which put us beyond, which is beyond the even ideas of people who frame the conception of of the Indian Penal Code at that point of time. 1857 is a different country. There's a wonderful saying in English which says, past is a different country, they do things differently there. So, completely and in a different context. Now, to balance both, and especially there are two other things which I would like to flag, and these are extremely important things. One is, how do you contextualize in the Indian context? I think in Indian context, Chanakya on a number of times, including all Indian thinking, and came down very strongly against anyone trying to subvert the state. Because it is, in Indian jurisprudence, we believe that there cannot be Matsanaya. The object of the state is to ensure there is no Matsanaya. The object of the state is to ensure order. So we have to look at it in that context. We should also look at it in the context that, to protection of dharma, you need, in some ways, the intervention of the state. And it was called danda, not only danda as in punishment sense, but danda as a way to ensure the protection of the state. So, and the last issue which I would like to flag is we are all a post-colonial state. And as post-colonial states, we should be aware of the history of the former colonial regimes using and continuing to use the differences amongst us to perpetuate them and to weaponize them. It happens every day, it still happens, we've seen it on the net. So we have to be conscious of that. So to that extent, these changes in the Act are very important. Now, there are three major changes, and I'll say this and I'll sort of conclude whatever I have to say. One is the changes, if you've seen those earlier provisions of the IPC. The first change is, previously you cannot create disaffection against Asiatic powers. So there's a large provision, you cannot carry out any action against Asiatic powers, etc., etc. India is now a global country playing on the global stage. It has connections all over the world. So from Asiatic powers, a fundamental difference is foreign powers, which I think brings into focus India's role in the world, how we see ourselves. So I think that's a fundamental change and reorients the code, otherwise things have been retained largely, those same provisions have been retained. But Asiatic powers have been changed to foreign powers, which is reflective of both the interconnectedness of the world, because you can be in Brazil and still, Brazil may be an important power for us, Kenya may be an important power for us, European powers may be important for us, so it need not only be Asiatic powers. And the British thought and saw India as largely a part of Asia, and that was its role. The fact that we expanded that, that's a good thing. Second issue is, of course, as we were discussing, this entire conception of sedition, and this, as I said, the question was, there are two competing things, that you cannot create disaffection, but you can create disapprobation against policies of the government. So this was supposed to be the safety valve. But I think now what has been changed, I think the fundamental change is endangering sovereignty, unity and integrity of India. And I think it's been an inclusive provision. I think very interesting is it's been enumerated. The provision enumerates, and I'll just go through what it sort of enumerates. It sort of encompasses secession, armed rebellion, subversive activities, including sovereignty, unity, anything which goes against unity, integrity, and of India. So it's very widely defined, but it does keep that explanation intact, which says that if you want to change government policy and in a peaceful manner, then that's an exception. So I think that balances the safety valve in a certain way. So I think that's a good provision, and I think it reorients it from merely something which creates disaffection against the government and which is very colonial in nature to something which comes directly out of the Article 19.1 restriction, 19.2 restriction of the Constitution. So in many ways, the new provision is more akin and more in line with the Constitution than it was previously, which was a colonial act. So in that way, it is different. The third thing, which which was marked right in the beginning, is the definition of terrorism. I think it's good that it's been included. I think that's good because I think that criminal law should be consolidated. I also think that in many ways, action which has been sort of demarcated, the criminalization which has been demarcated under the Act is complementary to sedition. Though sedition is very much discussed, I think it's very important to discuss the definition of terrorism because, as you know, anyone who knows criminal law, international criminal law, terrorism has been very, very hard to define. There have been conventions which have been trying their level best to define terrorism, nobody failed in the world. So even in India, it was, we've been hanging around trying to define what terrorism is, but at least for the first time it defines terrorism as, against integrity of the country, thereafter integrity, security, or economic security of the country. This is for the first time that is brought in. I think that's very interesting, saying that in today's world, the action which you can initiate, which people can initiate, need not only be against, as we see it very clearly, trying to overhaul the state through physical violence, but, to what end? It can also be against the economic security of the country. And, strike people, and includes, and there's another thing, what are the means by which you can use it? You can use, it narrates, you can use biological, nuclear, radioactive material. So if you use a biological weapon for, for these activities, economic activities, threats to overall the state, or nuclear material threats to overall the state, that would also come under terrorism. So, I think it's a wonderful, it's a provision which is, it's a step forward. It keeps in line with the Constitution. Whether it is wonderful or whether it is controversial would eventually have to be worked out by the courts. Everywhere, in every provision, as we all know, especially provisions which affect liberty, you need the courts at the very end to put in the guardrails. Because this is a continuous struggle between the forces of order and the forces of liberty. You know, you can't go, as being a part of the government, that's my realization, that when you're out of the government, you think liberty is everything. When you're in the government, you think order is extremely important. And this is a continuous struggle. But to strike the perfect balance, that is why the courts are important. That's why all of you are going to be important. That's why the jurisprudence which are going to be laid down in future are going to be important. Because cases vary. It depends on situation to situation. And the question of equity, the quality of mercy, which is the famously quoted, is of course the place, the residue is with the court. So we think that I think it's a great beginning. It's an updation of the law. It's like getting, finishing our colonial legacy, creating it for a new India. But it is our responsibility of the lawyers who are present here to take this forward and to ensure it works, to ensure the liberties of the people are protected. In all the while, it's also the responsibility of the court to ensure that order is maintained. Thank you very much.
Thank you very much, Mr. Vikram Banerjee. You've drawn, the historical perspective of the law, spoke about approach to sedition, jurisprudence which has been in existence on the issue, the colonial link, linking the freedom fighters who have been tried under this particular act, the numerous judgments which are there. He spoke about the new India's requirement with obviously what the British faced. Well, he also spoke almost literally about the international relations. Where he spoke about the parliamentary debates, the issues discussed between Sardar Patel and K.M. Munshi, and also about Shyam Prasad Mukherjee. I feel a little connected to Shyam Prasad Mukherjee, attempted to talk a little about him. In fact, he is the one responsible for what has happened in J&K today, resulting in its total integration with the country. He was the one, as a minister in Nehru's cabinet at that point of time, led the Praja Parishad agitation and went to the state of Jammu and Kashmir. At that point of time, J&K had a prime minister and a permit system. One could not enter into the state of Jammu and Kashmir till 1964. So in 1953 he went to the state. At the border he was arrested and incarcerated in the jail under the same laws. And he dies in the Srinagar Central Jail. Subsequently this picked up. He was the one who was given a call, Ek desh mein do pradhan, do vidhan, do nishan. Means in one country there cannot be two prime ministers, two constitutions and two symbols cannot exist. So that has subsequently caught, and this system has been abolished in 1964, and then they started the prime minister, from prime minister they switched over to the governor and to the chief minister that unlearn and relearn. Then we also know all these laws are prospective in nature. So what happens to the cases? There are a large number of cases on which there is at the moment there is a stop. The cases are under trial. They continue to be tried under the past laws, old laws. And the new laws under the new sections under 152 of the BNS, which are very, very elaborate. So what happens to that? Some of the laws are extremely progressive in nature, like trying proclaimed offenders in absentia. Today you can only attach their property, but you cannot try them in absentia and then convict them. Now it's very, very progressive. Similarly, time-bound investigation, you cannot keep on dragging on forever and ever and ever and ever. The number of adjournments have been brought down. Time period for investigation has also been laid, even for judgments, and acceptability of electronic and digital evidence, forensics, so on and so forth. All said and done, the BNS is really, as Mr. Banerjee has said, a transformative act, but the challenges will continue. Earlier, we had 1,000 odd laws, in all the three laws put together, the IPC, the CRPC and the Evidence Act put together, it was 1,000 odd. Now, we have another 1,000 odd laws in the new BNS. All put together, there are going to be 2,000 laws with which we need to grapple with. So, ladies and gentlemen, I rest my case here and my lecture. It is for the youngsters here. I find a lot of youngsters. You have a huge task in your hands. Whatever you have learned till date, now you need to further reorient yourself. I'm also extremely grateful to India Foundation for giving me this opportunity to chair this particular very, very important session, which is going to affect the future of our country, taking it forward into the 21st century. Not just take it forward, we are looking at being a 5 trillion economy. We are looking at becoming number 4th economy in the next 5 years. With this, I think the session is to be concluded. I hand over the mic to my, yes, what's your name? Well, to you. Thank you so much.
Thank you, sir. I'm aware I'm standing between you and lunch. So, before we end the session, may I request the dignitaries on the dais to be felicitated. First, starting with the chair for the session, Rajendra sir, may I request Mr. Srinivas Rao to please come and felicitate the chair for our session, Mr. Rajendra Kumar. Srinivas Rao. Next, may I request Avnish ji to present a token of appreciation to Vikramjit Banerjee, Additional Solicitor General of the Government of India. And finally, may I request Mr. Manav Kumar to present a token of appreciation to Professor Balraj Chauhan. Taxman Publications, on behalf of the organizers, has got copies of the Bharatiya Nyaya Samhita for the speakers on the dais. May I request Abhishek and Vijay from Taxman Publications to present a copy of the Bharatiya Nyaya Samhita to the speakers.
Sir.
Thank you. With that, may I invite my colleague Hamza to present the vote of thanks for the event.
It's my honor and a great privilege, ladies and gentlemen, to propose the vote of thanks for all of you. It's a very timely and thoughtful conference, and thank you all for being here. I thank our Chief Justice, I thank our Chief Guest this afternoon, Justice U. Lalit, and all our esteemed speakers today. Our special thanks to Justice J. Madhavi Garu, Honorable Judge of the Telangana High Court, for taking time and sitting through this entire conference. Thank you, retired judges, Vijay Lakshmi Garu, Seshasena Reddy Garu, Praveen Kumar Garu, for taking the time out and being with us today. I thank my senior colleagues at the bar, senior counsels, public prosecutors, government leaders, my dear brothers and sisters, law students, and ladies and gentlemen for the time and patience and your presence at this conference. I thank Nalsar University, Professor Sri Krishna Devarao Garu, Shanti ma'am, and your entire team for putting this together and being with us. I thank our venue partners, the Archdeccan and its staff, for your warm hospitality. I thank Sri N. Ramchander Garu, Avnish, Madhukar, and Manav, and his entire team, without which this event would not have been possible. I also thank, last but not the least, my colleagues from India Foundation, Apurv and Yash, who have flown in from Delhi to make this event a grand success. Thank you all. The lunch is awaiting you in the hall next door. Thank you so much for being there. Look forward to seeing you all in more events to come.
Sunil.